versus Christopher Caleb Watson. Defendant waived formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 25th, 2023 in Jefferson County, Texas, you committed a state jail felony of burglary of a building. Do you understand what your charges are?
Yes, sir.
If convicted of a state jail felony like this, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and sentenced to 18 months in the state jail. Restitution is ordered in the amount of $600. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How are you going to pay the restitution?
I don't know.
How are you going to pay the restitution? They need to get, well, that their plan needs to be in place before I accept the deal. I mean, I don't have to take this deal. The victims want their money back for the loss.
I didn't pitch restitution.
How you going to, sir?
I didn't pitch restitution, so this came from you, restitution.
Yeah. Well, I'm not going to take a deal if you don't have the money to pay it. You can just sit it out for 2 years.
Judge,
No, that's what the people want. The people
No,
want to
Judge,
pay-
hang on.
You're gonna get them.
what is the restitution for?
It's
What's it for?
You broke the front door glass.
Yeah.
I guess it's probably for that. That looks like what the damage is. And it could be that much, you know, if it's a big door. That's all it is. But it's not a debate. It's, they put in for they said they're owed $600. And I deal with the people. They're just not defendants in the trial. You got victims.
Yes.
And victims have a say. It was a loss. And we're going to try to accommodate them when they are lost, on a loss. People will say, why are they making a deal? And I'm out the money. What did they do to get a deal? And I have to deal with those directly, sir.
For you.
Sir.
For you.
Sir.
Oh, what's your judgment on the case?
It's 600, you're gonna have to pay $600. I'm not gonna take the deal. Sir,
600 is not days.
sir? I'm sorry, what'd you say?
600 is not days, it's money.
600. Okay, fine. That, I understand that. I don't have to take a deal.
So I.
So we'll just put it on the trial docket. And when it gets around to getting ready for trial, we'll try. That's what we'll do.
I don't know what restitution is.
Restitution is payment for loss.
Oh,
And the people say they lost $600 worth of something, and it's apparently the glass that was broken when you burglarized the building. I don't see another loss. But that has to get paid.
but it was lost.
$600 loss. And they're gonna say, why did he get a deal? If we're
He
out the
didn't get a
money.
deal. He didn't get one.
Sir,
He didn't get a deal. He
sir,
got a deal canceled. His deal got canceled.
yeah, you can serve 2 years is what the law says. You can serve up to 2 years. And that's, and a deal, and a plea agreement, look it up. There's no right under law for that. There is no right under law. And you're looking at up to 2 years. That's what the law states. And I don't have to accept it. It's a privilege that's trying to move cases. But if the people say, we need our restitution back, they're going to get accommodated. It's not right. If I was injured and they got a deal, didn't they? Well, that's nice. Where's my $600? There's no way you can find that money? There's no way somebody can help you with that?
No, you don't give that chance. You don't give that kind of chance. You're gonna let me out of jail. I was gonna get the restitution money, and then we just weren't gonna do that because there was
No, this
restitution
wasn't a
money,
probation.
and now I'm not gonna do
This
it.
wasn't a probation.
So 6 more months then, 6 more months.
This wasn't a probation.
Over 600.
Okay. No, we just said for trial. That's all. Thank you.
You gotta know how to decide something, Judge. You gotta decide something. You can't.
Sir,
flip
sir,
flop
I'm
with the
sorry.
decision making.
I'm sorry. You don't make the rules in this courtroom.
No, I make decisions. That's
The
why
law
I make
does.
decisions.
The law does. The law says you have a right to a trial and we will accommodate that. We'll set it for trial. Thank you.
Judge, you want to bring up the client?
Please. Schreiber, come up. So Mr. Schreiber's on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member.
I want the truth. You can't handle the truth.
You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today in the back in the witness room.
Who is the
So
complaining
my
witness in the
understanding is
harassment?
that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 8/10 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and his wife is here in court, Mr. Schreiber's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how long he will be there, but I would anticipate it's going to be not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. When you have actions, you take the wrong action. There are no mistakes in life. There are actions. And when you take the wrong actions, there's serious consequences. I'm now revoking your bond on the harassment case. You're staying with me. Now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still want to go to rehab?
Then we'll talk about that.
We'll work through all the, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence. And the way that I do that are with these devices, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? So what does wife want? Does she want to continue to have contact with him?
She is here to ask that the court modify the conditions of the magistrate order for emergency protection. Since this incident happened, Mr. Schreiber's been living in a hotel. They've abided strictly even with their communication and transportation today with the no contact. However, she is asking that we remove that restriction and instead go with the no threatening or harassing communication.
I've spoken with her and confirmed all of counsel's represented, and we're not going to be unopposed. We're not going to be opposed to modifying it to no threatening or harassing.
So you have an order for protection that's been put in place by the magistrate. I'm leaving everything in that order intact except for one thing. Well, I guess two. Does the MOAP also say no contact as well?
It says no contact and don't go to their.
Got it. Okay, so I'm going to modify two things. The first thing I'm going to do is I will take off the residential restriction. Number two, I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand what is threatening or harassing doesn't matter what you think. I could give a rat's behind what you think. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in custody. And I'm going to tell you now, any more issues?
That's why I'm going to rehab, sir. Yes, sir. I understand.
There are people in life when they drink, they're very happy, they're the life of the party. Yeah, and then there are people who develop horns when they start drinking. If this is you, there's one easy solution. So what we'll do is I'll put the monitor on him. I'll waive the fee. Okay. I guess, correct. No alcohol, no drugs, random testing, no weapons, no threatening or harassing contact with the complaining witness, the scram monitor, waive the fees. Get with me as far as the facility and what they say about him having the device on, and if they're okay with it, if they're not okay with it. If they're not, then we can work something out. But the minute he gets out, the next day he's got to get the monitor on if they have a problem with it. And then you must charge this device every single day. If the battery goes dead, so does your bond. Do you understand? All right, so I'll set the new bond at 5,001 on the harassment case, and then we're done. All right, goes with you. Okay, Mr. Downey, so just
We'll get a reset, maybe 45 days out, should give us enough time.
do that. I need proof though. Like, you get me proof that he's actually enrolled and how long he's going to be there. On the harassment case, he's going to make bond. They'll give you a 7-day setting on that afterwards. Feel free to get with Victoria so that way you can match up the date after you get the new date, and then, okay. All right, guys.
If you are new to my channel, please subscribe as I edit these cases and remove all of the mundane, boring, repetitive stuff. And I even remove the silences, so you get only the juicy bits, which I think are always the best bits. Are looking for another episode that has all the boring stuff cut out and gives you just the good stuff, then here a couple that may interest you. Enjoy.